Hi, everyone. Thank you for joining us. It always takes just a minute for everyone to come into the webinar. So we'll give it about 30 seconds and then we'll get started. Okay, well, we'll get started. Welcome, everyone. Thank you so much for joining us. My name is Tony Wilken-Givart. I am Executive Director of Midwest Environmental Advocates. And for those of you who don't know, Midwest Environmental Advocates is a nonprofit environmental law center that combines the power of law with the resolve of communities facing environmental injustice to secure and protect the rights of all people to healthy water, land, and air. We put our legal expertise in the service of communities and grassroots groups, helping them to extend their power to defend the people and the places that they love, to protect their homes and their communities. And tonight, we're here to celebrate a victory that's very related to that work. It's our victory in the Spills Law case that came after a number of years of representing grassroots groups and impacted communities in that dispute, which we'll talk about in just a minute. But first, I want to introduce the panelists that we have here with us today. My colleague, Rob Lee, staff attorney at Midwest Environmental Advocates, is joining us. Hi, Rob. Thanks for being here. Allison Warner, executive director of the River Alliance of Wisconsin, is here. Thanks, Allison. Dean Hoger, president of Clean Water Action Council of Northeast Wisconsin, is joining us tonight. And Tom Killian, who is a founding member of Citizens for a Clean Wausau. Thanks for being here, Tom. So just to give everyone an overview of what we're going to do tonight, I have a short presentation about the Spills Law case. Then we'll have a panel discussion, and we'll have time for some questions at the end. And folks can put their questions in the chat, and we'll take as many as we can at the end of the webinar. Okay, so let's get started to talk about this case, which is a setup to the victory that we achieved. So back in 2021, Wisconsin Manufacturers and Commerce, which is the state's largest and arguably most powerful business lobbying group, sued the DNR in an attempt to limit the state's authority under the Spills Law, its authority specifically to regulate PFAS as emerging contaminants. But its legal arguments also included all of DNR's authority to regulate hazardous substances under Wisconsin's Spills Law. It's worth noting that this is not an isolated incident. This is part of a pattern in which WMC and allied special interests have used litigation in attempts to roll back environmental protections, to get the courts to undo environmental protections in ways that would be deeply unpopular if they were proposed in the legislature. So this all started in 2021. And over the course of the next 4 years, Midwest Environmental Advocates, on behalf of our clients, filed multiple briefs at the circuit court level, at the Court of Appeals, and at the Wisconsin Supreme Court. The clients that we represented were the Wisconsin Environmental Health Network, River Alliance of Wisconsin, Clean Water Action Council of Northeast Wisconsin, Citizens for a Clean Wausau, and Doug Oitzinger, who is a former mayor and current city alder in the city of Marinette. MEA and our clients got involved in this case back in 2021 because we felt compelled to make sure that WMC did not succeed in gutting the state's spills law. The spills law is a key environmental protection that has kept Wisconsinites safe from exposure to hazardous contamination for nearly 50 years. It is an essential tool that is often quietly working in the background, but it is essential for holding polluters accountable and providing assistance to impacted communities when hazardous substances are released into the environment and contaminate water and soil. Importantly, the spills law gives DNR the authority and the flexibility to determine whether a substance is hazardous based on the specific circumstances of the release of that discharge. And it also gives DNR the authority to direct responsible parties to investigate and to clean up those releases of hazardous substances. So, as I've said, for almost 50 years, the spills law has been key to protecting public health and natural resources in our state. It has prompted cleanup at at thousands of sites of industrial contamination where hazardous substances have been released. That includes not only emerging contaminants like PFAS, but other industrial pollutants, manure spills, the release of agrochemicals. No matter where you are in the state of Wisconsin, it is very likely that there is a historic site of contamination near you that has been addressed through the spills law. The map on your screen is a good representation of that fact. In its lawsuit, Wisconsin Manufacturers and Commerce made the claim that until there is a list promulgated through the rulemaking process, that the DNR has no authority to order investigation and remediation of any hazardous release of a hazardous substance. Um, and this is counter to how the spills law operated over the course of those 5 decades. Making a list would actually mean that the state would have to go through a complicated, protracted rulemaking process that is notoriously prone to special interest influence that would likely drag on for years if it was ever completed. So had WMC succeeded in advancing its legal theories, the spills law would have been effectively repealed indefinitely. Okay, that's what was at stake with the legal arguments. Let's talk about the public health impacts. Um, Focusing just on PFAS here, the consequences for Wisconsin families would have been devastating, especially for communities like Marinette and Peshtigo and other communities in the state that are impacted by PFAS contamination. PFAS, even at extremely low levels, pose serious risks and health problems. Those health problems include an increased risk for certain types of cancers, reproductive and developmental problems, thyroid hormone disruption, high cholesterol, ulcerative colitis, and decreased response to vaccines. And just to put this in context and to give you a sense of how potent and toxic PFAS are, we can compare them to other contaminants that are regulated by the federal government under the Safe Drinking Water Act. So under the Safe Drinking Water Act, EPA has a duty to establish maximum contaminant levels for substances that may pose a risk to drinking water. And EPA has done that for over 90 contaminants under the Safe Drinking Water Act. Um, Many of those contaminants are toxins that are household names. So, for example, the maximum contaminant level for cyanide in municipal drinking water is 0.2 parts per million, and that's roughly equivalent to 1 drop in a bathtub full of water. Arsenic, the maximum contaminant level, is equivalent to 1 drop in 25 bathtubs of water. Atrazine, equivalent to 1 drop in 85 tubs of water. But compare that to PFAS, and I'm speaking now specifically of PFOA and PFOS, which are two of the most commonly studied PFAS compounds. The maximum contaminant level for PFOA and PFOS is equivalent to 1 drop in 65,000 bathtubs of water or 5 Olympic-sized swimming pools. So that's how toxic PFAS are. And it's important for us to just take a step back. As we as a state were facing and continue to face one of the most pernicious and vexing environmental problems related to the release of a hazardous substance. One of the most vexing problems over the entire 5 decades the spills law has been around. WMC, through the litigation, attempted to render the spills law effectively useless. But throughout the 4 years of litigation, MEA attorneys, and Rob was in the lead on this, worked with our clients to push back against that effort to make the spills law unenforceable. As the lawsuit worked its way up from Waukesha Circuit Court at the trial level through the Court of Appeals and then to the state Supreme Court. As you may know, this summer, the state Supreme Court issued a decision that vindicated the DNR's efforts to keep Wisconsinites safe from toxic substances like PFAS through the spills law, a result that we were very, very pleased about and that we're happy to celebrate tonight. So let's get some other voices into the room here. And Dean, I'd like to ask you, this is not the first environmental protection lawsuit that your organization, Clean Water Action Council, has been involved with. You have a long history of being involved in impactful litigation. Could you tell me just a little bit more about your organization, tell the audience more about your organization and how your participation in the Spills Law case fit within your organization's mission? And feel free to come off of mute. Dean, are you with us? I think we've lost Dean, hopefully just temporarily here. Dean, you're frozen if you can hear me. Is everyone else? Rob, can you hear me? Just to verify? Okay, great. Well, I think what I'll do while Dean is getting reconnected is...
am I back?
You're back.
Okay.
You're back. You're back.
I had difficulty unmuting. So thank you for that introduction, Tony. Clean Water Action Council's mission is to protect human health and the environment. And we do that through basically through education. That's primary. But then we also do a lot of community organizing. And sometimes we have to take legal actions. That might be in the form of getting local ordinances passed, or in some cases, taking cases all the way to the state Supreme Court. Our board believes that it's an important part of our obligation to help our members and our citizens to take legal actions, because people just don't have the resources to do that. So we feel that when we can do that, we definitely want to be a party to that. And we appreciate the opportunity that MEA has often given us to be part of legal actions. So we have taken a number of actions over the years, including ending wastewater pollution in a operation in Oshkosh, also improving air quality in Appleton, and preventing the construction of a gasification incineration plant in Green Bay. So, is my camera off too, or?
It is off, yeah. So if you want to try to turn it back on, that's great. But we're glad to be hearing you loud and clear.
All right, so great.
It seems like it didn't come back on you. So if you want to keep it off and continue talking, that works just as well.
Okay. So that legal actions are a really important part of fulfilling our mission to our members and the community. So we're very pleased to have an opportunity to take part in this action.
Great. We were glad that you were able to work with us over these many years as well. Dean, as you know, we filed a number of Friends of the Court briefs throughout the course of this lawsuit, and several of those briefs warned that a victory for Wisconsin manufacturers and commerce would have had devastating impacts, especially in Northeast Wisconsin and places like Marinette and Peshtigo, which we alluded to earlier. So could you talk a little bit about why this issue impacts Northeast Wisconsin in particular and what you're seeing up there?
Yes, the spills law will continue to give the state authority, the DNR authority, to hold polluters like Tyco, Johnson Controls accountable for their role in making Marinette one of the worst sites for PFAS contamination anywhere in the country. Now, CWAC became involved by helping citizens organize when Marinette residents became aware of PFAS contamination in their groundwater and private wells in 2017. And within a year, they learned that it was also in surface water and wastewater, and in biosolids that were being spread on agricultural fields. So now local residents cannot safely drink their tap water, eat local fish, and as well as game, and enjoy their local natural surroundings. Now, corporations like Tyco Johnson Controls, who profited from releasing these toxic chemicals into our environment, must be held accountable.
Thanks, Dean. And I'll just note that over the course of time that this lawsuit, this challenge by WMC is pending in the court system, um, the Department of Justice, the State Department of Justice's enforcement action against Tyco Johnson Controls under the spills law had to be put on hold. So up in the Marinette Peshtigo area, in some instances, and with respect to some sites of contamination, Tyco Johnson Controls took um, investigatory and remediation actions in response to the spills law. And then for a wider area has been disclaiming responsibility and not taken action with respect to those parts of the community. And the DNR and state DOJ are prosecuting Tyco Johnson Controls for its failure to live up to the full obligations of the spills law. But that whole case had to be put on hold until the state Supreme Court resolved the legal issues. We're glad that the path is cleared and that action can get back on track, but it does speak to the fact that there was some damage or delay as a result of WMC's lawsuit in that regard. Tom, I'd like to turn to you and talk a little bit more about something we mentioned earlier, is that this lawsuit didn't just have to do with PFAS, and it wasn't communities that were impacted by PFAS that were the sole communities at risk based on this action. Um, could you talk a little bit about why Citizens for a Clean Wausau got involved with this case and what perspective you brought?
Sure, Tony. Our community here is directly impacted by the DNR's ability to regulate hazardous contamination under the spills law, particularly diverse working class neighborhoods in Wausau that are impacted by industrial contamination. They're especially reliant on the DNR's ability to require investigations and cleanups from responsible parties. And just to give you an example of scale, according to the DNR's remediation and redevelopment database, there are at least 19 sites that are open in Wausau right now where investigation and cleanup of hazardous substances are taking place. Just in my neighborhood, there are 4 open environmental repair program sites in a 1 to 2 block radius, just to give you an example of the cluster that can occur in certain working class areas. And the spills law has enabled Citizens for a Clean Wausau to monitor and address industrial contamination that impacts residential areas, but also recreational areas like parks in our neighborhoods, or even the Wisconsin River that flows through the neighborhood here.
Thanks, Tom. And over the course of time that we've been working on this lawsuit together, I've had the opportunity to visit you and spend some time in your neighborhood. Could you talk a little bit about the kind of the concrete ways that the spills law has helped in your community, and also what are some of the remaining challenges?
Absolutely. So, just a couple examples of where there's been progress in ways that have been facilitated by the spills law. Riverside Park in our neighborhood, the public park, had a long-standing dioxin soil contamination issue. And just in recent years, under DNR oversight, it has been tested and has been under remediation. So an extensive amount of soil has been excavated from the park. Also, a property along Cleveland Avenue, once part of what Wausonians used to know as the Connor Forest Industries property. It's finally been tested and will undergo remediation as well. So those are some examples of progress that correspond to the spills law, Tony.
Tom, and I know that progress doesn't happen automatically. I know that you and your community have fought very hard and tenaciously to make sure that that soil testing and remediation, especially in Riverside Park, happened. And you're to be commended for leveraging the spills law to make kids, families, Wausonians safe or safer at least in Riverside Park. So thanks for all that you do. Allison, we've talked a lot about the environmental impact of
Thank you, Tony.
contamination.
And just
Please go ahead, Tom, please.
my apologies, there was a little delay. I was just going to say thank you. And I think these situations often with contamination, it does take a village, and it's often regular people against undue corporate influence. Thank you.
Yeah, thank you, Tom. Allison, we've been talking about contamination and its impact on public health. And that's a reason that a number of groups were involved. But I want to just switch gears and ask you to talk about why River Alliance of Wisconsin got involved. And certainly public health was important, but you brought other perspectives and interests to the case, and would just love to hear a little bit more about that.
Absolutely. Thank you, Tony. So River Alliance of Wisconsin, we chose to get involved in this case because as a statewide organization that's been empowering people to protect and restore the waters of Wisconsin for more than 30 years, we believe that preserving the integrity of the spills law is crucial to the DNR's ability to protect Wisconsin's rivers, lakes, and our other water resources. As you stated, Tony, and we've talked about tonight, the health of our water resources is important to environmental and public health, but it's also for the health and vitality of Wisconsin's tourism-dependent communities. Our tourism industry here in the state of Wisconsin, which contributes billions to the state's economy every year, depends heavily on our water-based recreation like fishing, boating, and swimming. Hopefully, many of the folks listening here today are out there enjoying our waters all across the state and have seen lots of other folks out there. And so in 2024, it was another record-breaking year for tourism here in Wisconsin. The estimate economic impact for the tourism industry here in the state last year was $25.8 billion. And that's the third year in a row the state's tourism dollars have broken records from people, all of us Wisconsinites who love our waters, but also our friends who come to visit here. These numbers, again, have been tracking for a long time. In 2023, tourists contributed $1.7 billion in state and local taxes and $1.4 billion to federal taxes. So the tourism economy is just one other piece of why it's important to keep our waters clean. Of course, our ecosystem and public health is important too, but as many folks listening tonight may have experienced, a spill that contaminates a river or lake can result in fish kills, toxic algal blooms, and degradation of aquatic habitats. So these impacts harm our ecosystems, but also deter tourists who want to fish, boat, or swim in clean, safe water. So if Wisconsin, I hope we want to continue to be a destination for water-based recreation across the state. It's part of our reputation and our heritage here as a water-rich state. So we want to make sure it's safe for people to drink, fish, and swim. And we want DNR to have the ability to enforce the spills law in a timely and effective way when there are pollution incidents and prevent long-term harm to our water resources and to our tourist industry.
Thanks so much, Allison. And for our final panelist, I want to invite Rob Lee, staff attorney at MEA, into this conversation. Rob, I've got a specific question for you, but just want to first say that you, in many ways, were the leader of this effort. So anything that we didn't cover, or any reflections that you want to offer about your 4 years advocating for the spills law and the victory that we achieved this summer?
Appreciate you putting me on the spot there, Tony. First thing is what a privilege to get to represent the four organizations, and Doug Waitzinger, the former mayor and current alderperson up in Marinette, and to be right working alongside you in this fight, right, and to be able to go to folks with members in these communities, right, that stood to lose and gain from this lawsuit, right? The fact that each of your organizations and got it right when this lawsuit was filed, and were willing to get in the fight and work alongside us all the way to the Supreme Court was awesome. And the outcome was never certain. I don't think, especially when this case first started. And so just added a whole lot of value to it, and I think fundamentally changed the trajectory of that case. And so I really think a thank you to all of you, your members, the folks in these communities that we gotta work on. And when Tony says we're here to celebrate, we very much are, right? So I want folks to understand, yeah, this may have been working in the background for 45 years or so, and maybe even been taken for granted, but you would have been well aware had it gone away. And this is a big deal for the Supreme Court to come down and affirm the authority DNR's always had, that the legislature gave it way back in 1978. So I'll stop there. I could go on for 2 days, but it sounds like you might have an actual question in there, Tony.
Well said.
A
Yeah, I've got a
substantive one
I've
anyway.
got a specific legal question for you. So, we've been talking about the fact that, as you just said, DNR's ability to protect public health and the environment was at stake in this case. But there was also another case that was recently decided by the state Supreme Court that presented similar issues. So could you talk to us a little bit about that case and how it's connected to the Spills Law lawsuit?
Yeah, so the case you're talking about is Evers v. Markline. And there's actually a couple of different versions of it. Don't want to confuse you, but the final decision was issued this summer, right around the time the Spills Law case was. And the similarities between the two, broadly speaking, are that it would have implicated the ability of DNR to take actions that do address PFAS contamination. Let me explain why a little bit. The Spills Law case was about DNR's authority to regulate PFAS, and by extension, any hazardous substance that wasn't on the list, right? But they were really going in the first instance after PFAS specifically. Evers v. Markline, and part of that, right, about the Spills Law case, saying, hey, you need to promulgate the list through the rulemaking process. They're trying to funnel it to the rulemaking process. Evers v. Markline was generally about the ability of just a small number of legislatures on a committee to usurp for themselves the lawmaking process, whether it was by withholding money that the full legislature had already appropriated, or vetoing administrative rules, right, passed by state agencies without going through the constitutionally required legislative processes of bicameralism and present it. Both houses got to pass it. You got to present it to the governor. You can't just have a committee functionally make law. So in Evers v. Markline, MEA also had the privilege of representing two organizations that aren't with us today, but I want to give them a shout out: SOH2O, Save Our Water up in Marinette and Peshtigo, and Wisconsin Conservation Voters. And there we argued and pointed out what the real world consequences of these committee of vetoes have been. And that those were much more harmful than previous court rulings had acknowledged. So the example we pointed to in the PFAS context was a 2020 committee veto of a DNR rule um, that was promulgated, to implement a law that was designed to prohibit the discharge of any PFAS-containing firefighting foam down the sewer. Really a law that was targeted at Tyco Johnson Controls operation up in Marinette and Peshtigo, because they'd just been discharging the foam that they had manufactured or tested and all the things right down the drain. And community members up there went to their legislature with this problem and thought they had believed they had gotten a bill passed that would prohibit the discharge of that stuff down there. But the committee veto came in there on the Friday before Christmas. They decided to meet at the behest of an industry request to weaken important, crucial monitoring requirements that DNR wanted to put in this rule to ensure, right, that the PFAS were being removed and not going down the drain. And so at the 11th hour, this, again, a handful of committee members came in and said no. And fundamentally changed the way that law was designed to work. And so now Tyco Johnson Controls gets to continue to discharge PFAS down the local sewer at elevated levels. So it's really problematic in practice across a variety of contexts, but even here in the PFAS context. And in that case, back at earlier or last month, the Wisconsin Supreme Court ruled that those types of committee vetoes violate the state's constitution, the separation of powers there. So I think the real connective tissue between Evers v. Markline and the spills law, it just comes back to our administrative rulemaking process and how really starting in the 2010s through now, but even a little bit before that, has been broken by design. And what was WMC trying to do in the spills law case? Funnel all regulatory authority back through a rule-making process that they know is broken, that they know DNR can't overcome, and that will functionally result in a repeal of the spills law and a windfall for their members, right, who will no longer have to pay for the excesses, right, of their businesses and force those onto regular folks. And that's wrong. So anyway, I do think spills law case is important, but I think Evers v. Markline is going to be really important as far as turning the tide, right, and pushing back against these changes to the rulemaking process so we can get back to adequate regulation and have an effective mechanism once again for updating public health standards based on science, right, and implementing the environmental laws that we do have. So that was a very long-winded answer, but I appreciate the question. It's an important one.
Thanks a lot, Rob. And I'll just offer a few kind of closing reflections here for this portion, and then maybe as I'm doing that, you could check the chat and the Q&A to see if we have any questions from the audience teed up for us to get to in just a second. So if folks do have questions, feel free to put those into the chat right now, and we'll address them in just a minute here. But building off of what you just said, Rob, spills law case and Evers v. Markline, on one level, seemingly different, but they share this common theme of reinforcing the state's capacity to implement and enforce environmental laws that protect clean water and a healthy environment in our state. And they turn back special interest attempts to put obstacles in the way of those protections and their proper implementation. While we're celebrating victories, and we need to savor every victory right now, another decision that is in that vein from this summer from the state Supreme Court was Call v. Legislature, where a unanimous court invalidated a law that gave the Joint Finance Committee control over settlement agreements in civil enforcement actions, including environmental enforcement cases. And that law had made it more cumbersome to hold polluters accountable, and it exposed the enforcement process to tons more possibility, at least, for political interference. So that was an important decision. And while we're recounting these victories, I think it's important to go back to the 2021 Kinnard Farms case, where MEA and our partners achieved an important victory. And there, the state Supreme Court sided with Kewaunee County residents whose drinking water had been contaminated by a large factory farm. And the court in that case rejected industry attempts and legal theories that would have restricted the state's ability to impose permit conditions that are necessary to protect water quality, both surface water and drinking water in the state of Wisconsin. The court affirmed that the state can impose meaningful conditions to protect water resources across the state. So as we're savoring the spills law victory and we're taking stock of it, it's also important to remember those other decisions. And together, I think they signal a really positive shift in Wisconsin. And it's important to note that while federal protections are right now, as we speak, facing an unprecedented assault, that those same or similar tactics on the state level are being turned back or being defeated. And so we have a lot of opportunity and reason to achieve progress here in the state of Wisconsin. It's also important for us to take stock of and underscore the vital role that community members and grassroots groups have played in driving all of that progress that I just talked about. So in the Kinnard case, it was 5 residents of the factory farm in Kewaunee County that persevered through years and years of litigation to secure a victory that right now is protecting all of us in the state of Wisconsin. In Evers v. Markline, in particular, the folks in Marinette who refused to back down after a legislative committee weakened the PFAS protections that they fought for, they kept pushing so that many environmental laws in our state can now be more faithfully executed and implemented in the future. And as we've been talking about here tonight, in the Spills Law case, it was the tireless work of our clients to ensure that the public and the courts saw through WMC's efforts to dismantle the law and make sure that we continue to have the Spills Law protecting us at a time when we need it the most. So we're going through, as we all know, an era of upheaval and attempts to erode environmental protections, particularly on the federal level. But I think we can leave tonight drawing strength from the unwavering determination of the folks who have joined us today and other grassroots advocates across the state of Wisconsin that have led to these victories. And I think we can draw inspiration that this kind of perseverance will make our state and our communities healthier as we move forward. These decisions will absolutely make a difference for a healthier future in Wisconsin. Okay. Do we have any questions in the chat? Let's take a look here.
Quite a few, Tony.
Okay.
Yeah. And I have answers to a couple of them if you want me to get
why don't
those
you
out of the
shoot?
way.
You've had a second here to take a look at them. So go ahead.
Yeah, one of the first question was, is it possible to get a copy of the rulemaking process chart? If you Google DNR, like permanent administrative rules, and just go to that page, you'll see a link there that says rulemaking process, and you can click through. But I want to say, even the chart that was on our webinar and the chart that you will find there isn't up to date because of the Evers v. Markline decision. The chart that was in our slideshow talks about the ability of committees to object or veto to rules, right? So that's actually lagging behind a little bit. And in fact, we got up to, I want to say 42 or 3 steps in the rulemaking process, and now we're down to 35 or 34. But yeah, some of the, that's how fresh Evers v. Markline is. So I'm hoping that gets updated soon, and we'll have a nice chart. But I just didn't want folks to rely on that exact version because, yeah, it's slightly outdated now. So there was that one, and then there was a question on how much are these decisions dependent on a liberal majority of the Supreme Court? Are they party line decisions? The answer is no, they are not party line decisions. The Spills Law case, you'll have to remind me the breakdown on the other two, but the Spills Law case specifically was 5-2. And that includes Brian Hagedorn, who's normally considered to be on the conservative side of the court. So this wasn't a party line decision. There was a dissent, and that's okay. But I don't think this decision could be revisited along party line grounds. Say they were the ideology of the court flipped. I think that would take some time before they could really get at this again. So anyway, Tony, I don't know if you have an answer for the other cases.
Yeah, the Kinnard Farms case was decided 4-2. That was before there was a quote liberal majority on the state Supreme Court. Then Chief Justice Annette Ziegler was in the majority. And then the Evers v. Markline 2. Well, there are two decisions in Evers v. Markline. One was 6-1, the other was 4-3, with a concurring opinion from Justice Hagedorn. So it wasn't a stark, quote, party line decision. And I believe call of the legislature was unanimous. So that just goes to show that some of the ways that environmental enforcement and the implementation of environmental laws, the way that has been operating over the last several years in Wisconsin was well outside of the mainstream, whether it be conservative mainstream, liberal mainstream, or just the mainstream. And it's great that we are moving back towards processes that are consistent with the Constitution and that will allow those laws to be faithfully executed. We've got another question here, and I'm gonna read the question, and maybe Tom, this relates to a little bit about what we were talking about, so I'll give you first crack at it. It says, this is from Greg Michelson, the decision confirmed the DNR's power to protect us from PFAS, but has the DNR exercised that power adequately? And maybe I'll just generalize that a little bit to ask, yes, it's important that the state Supreme Court has affirmed the state's power under the Spills Law, but has that power been used adequately?
Well, I think it's a very broad power that could be used to a greater degree. And I'll just give an example from where I live here on the southwest side of Wausau. With dioxin groundwater contamination, for instance, the groundwater standard in Wisconsin really relates to one particular dioxin, TCDD, but there's been concern and confusion here that the whole range and set of dioxins have not been tested for in the groundwater. And I would assert, particularly with the court's decision, that the DNR does have the authority to regulate in a broad manner. If there are adverse impacts potentially to humans or the environment, the DNR has broad authority. Do I feel like it's being used adequately? No, I do not. So I believe this is a step forward, and we can look toward our regulators to use it as completely as possible to make sure that not only the environment, but the people that live in that environment are adequately protected. Sometimes that means remediating not just soil and groundwater, but political processes as well. So I think we can look toward that hopefully more in the future.
Yeah, absolutely. The decision related to the legal authority is foundational, it's fundamental, but it still means that we as environmental advocates need to push, as you have done so skillfully in your community, Tom, that the power is exercised to protect our neighbors, our families, our communities. Well, we're coming up on 45 minutes here, but there are still a few questions that I think a number that we can kind of run through relatively quickly here. One person asked whether there was a chance that any of these, or that this particular case, the Spills Law case, could be subject to further appeals with the federal courts and the US Supreme Court. And the simple answer to that is no. This is an interpretation of state law, and the Wisconsin Supreme Court is the final authority on interpretations of Wisconsin law. So that is good news. This is a final decision. Someone asked if the legislature has released funding related to PFAS remediation and investigation, and the short answer on that is no. Unfortunately, there are a few people in the legislature who are determined to weaken the spills law and are using taxpayer funds as leverage to bully the governor and others into agreeing to weakening the spills law in ways that are similar to exactly what WMC was trying to do in this lawsuit. So it's incumbent on us to make sure that the public understands what is going on, and to make sure that, again, we need the spills law now more than ever, and that we don't weaken that legal authority and that protection, that ability to hold polluters accountable right now as we're dealing with PFAS contamination. And then just kind of looking at the comments here, one of our co-clients, or one of our clients with the Wisconsin Environmental Health Network, Dr. Beth Neary, who did an amazing job advocating on behalf of her organization and on behalf of us all in this case, pointed out that we should give a shout out to the journalist who covered this story. And I wholly agree with that. So much of what we needed to do was make sure that the public and the courts understood how essential the spills law is to protecting public health, and how fundamental it is to addressing PFAS contamination in Wisconsin. And I think the factual, careful journalism that we've seen in the state was an important asset that we had. I think that we've covered most of the questions. Anything else that anyone else wants to say?
One more, and it's another a Beth question, but Kara had posted into the Q&A here. And while we did do a great job, and journalists and everybody else trying to get the word out about this and explain this, right, there's still a whole lot of folks who aren't aware of, or even if they are, generally don't understand the spills law. And Beth asks, how can we inform people of this law that protects them? Beth, just give them my cell phone and tell them to call me. But short of that, there are resources available on DNR's website, on our website. But the biggest thing I think regular folks can do is use DNR's database. It's called BRRTS. It's BRRTS. And it even has an interactive portion of it with a mapping. You can sort it by county and municipality. But what you can do is educate yourself about these contaminated sites that are in your own community, and talk to folks about them that are around you. I don't know how many kids, right, see abandoned field and climb right over that fence, right? Not knowing that that field has historical contamination on it. That's just one example. I'm not trying to scare everybody, but I think that's the biggest thing. DNR has the information out there, and if folks, for folks to look at. And so I think that's the biggest thing is, how does this matter in your community and the people that are closest to you? Because that's what's going to make them care, not contamination somewhere else. Anyway,
Yeah.
I think
Thanks,
that's the best way, because it's not thousands of sites, Tony. It's tens of thousands.
Yep. Thanks, Rob. So we'll provide Rob's cell phone number, the link to the BRRTS site, and then probably Tom's phone number, because he is an expert navigating that site and doing historical research. Well, as we wrap up here, I just want to give an opportunity for any of our panelists to make any closing remarks or to say anything that you'd like before we wrap up. Nothing? Okay, well, I'll bring us home here and just say thank you to everyone for joining us this evening and sharing in the celebration. I see a number of MEA friends and supporters on the participant list, and want to say thank you to all of you for helping make this work possible. We were able to continue on tenaciously here over a period of 4 years to secure this victory, thanks to your friendship and support. And I know that the organizations that we represent likewise depend on supporters like you. So thank you, everyone, for being part of this effort and sharing in our victory. And we hope you have a great night.